Welcome to Impact Makers Radio, featuring industry thought leaders sharing problem-solving insights to help grow your business and live the life you love. And here's your host, Stewart Andrew Alexander.
Hi, and welcome to another Let's Talk Divorce conversation. And on this segment of the show, I have family law attorney William J. Rudnik of Gebhardt and Kiefer PC, all the way from Clinton, New Jersey. Now, William, or Bill as he's commonly known to his friends and colleagues, is considered to be a leader in the area of family law and is here to talk to you today about using alternative dispute resolution methods to settle your divorce case. So, if you are one of the many people in divorce in the Clinton, New Jersey area and you're wanting to know more about today's topic, you might want to take a break. Log out of Facebook. Come on, just give Facebook a break for 5 minutes. Maybe even switch off Twitter or Instagram or anything else you happen to be doing which may cause a distraction. And you know something, you might even want to grab yourself a notepad and pen. Take some notes as we listen in to what Bill has to share with us today. So with that said then, let's not keep him waiting any longer. Welcome to the show, Bill.
Thank you, Stuart.
You are so welcome. So let's just jump feet first in, Bill. Briefly, in your own words, can you describe the kinds of people who you help and the various types of situations they find themselves in when they reach out to you for your assistance?
Sure. The most common individuals are either thinking about divorce or their spouse has mentioned divorce. Some are simply looking for advice before the process starts, while others are trying to decide whether to move forward with the process, whether it's worth getting divorced, because it obviously takes a toll both emotionally and financially on parties. I see individuals who have problems or legal issues with their former spouse after their divorce. Some of my clients are also unmarried in relationships where they have children together or they own assets together. I also see individuals involved in domestic violence matters. Typically, with the alternative dispute resolution matters, they tend to be people who are starting the divorce process. The issues that I deal with in these cases are typically anything that would come up in a family law matter, from custody and parenting time issues to child support, division of assets, alimony and spousal support, contribution to college expenses for children, restraining orders, etc.
Okay, Bill, now that we know who you help, before we go any further, it goes without saying that anything you share with us today is not legal advice or legal assistance. It's purely for the purpose of sharing information. Now, with that said, I'm sure while you're out there helping the people who you work with, you come across many misconceptions. So, of all the misconceptions that you have to deal with on a day-to-day basis, what's the most common one you hear while you're out there helping your clients?
I would say the most common misconception I hear from clients is this notion that they'll get a better result by litigating their case because the judge will agree with their position after hearing their quote-unquote story. Many people want their day in court, and I understand that, but it really is a tremendous waste of time and money to litigate these cases. Typically, a trial will not take place until a case is a year old or even much older than that. And by that point in time, the parties have spent a lot of money and obviously a lot of time. And then once the trial starts, the trial itself can take months and cost a lot more than was spent by the parties to even get up to that point where they're starting the trial. Ultimately, the judge doesn't really want to hear the party's story because typically the story is what the client thinks is important. It's usually full of emotion, things like why they're a better parent than the other party, how they did more during the marriage than their spouse, why they should receive more than their spouse. Judges don't really care about all the emotions involved in the case. They care about the facts that relate to the specific factors that they use to decide the case. They're neutral, and they're typically not swayed by the emotion that comes from the parties. The better course of action is to use alternative dispute resolution methods to settle your case rather than going through the litigation process. So using some of the alternatives that you have, such as mediation or collaborative divorce, those allow the parties to be creative in settling their case, and they avoid the time and expense of litigation. We also know that cases that are settled by the parties rather than having a judge decide the case are more likely to have the parties follow that settlement in the future, less likely to have ongoing disputes or future litigation post-divorce. The process in helping people overcome their misconception about trials really starts the first time that you speak to a client. You try and explain the problems with litigation, the benefits of using alternative dispute methods, and really encourage clients that this is not a process where you want to battle things out or punish your spouse, that ultimately both parties lose when somebody decides to take that course of action. And if there are children involved, it really is taxing on the children when there's ongoing litigation that lasts for a long period of time. Usually people who want to litigate also tend to want to take an unreasonable position in the litigation, and taking a reasonable position is important even in cases that are litigated. I recently had a case where I was litigating the case and we were at trial. My client was questioning my advice because I had encouraged him to take a reasonable position throughout the process. He felt like his wife wasn't being reasonable, and he was thinking as though she was going to be successful with her unreasonable position. It wasn't until the end of the trial, when the judge agreed with my client's position, that he finally realized the benefit of my advice. Of course, if my client's wife had been more reasonable at the time and had agreed to either mediation or the collaborative process, they would have each saved about $50,000 between the attorney's fees and the expert fees. So, it's so expensive to litigate these cases, and you just don't get the result that you think you're going to get when you go into these with an unreasonable viewpoint.
So let's expand on that last thing, what you said, when you go into a case with an unreasonable viewpoint, and especially when it comes to the children, as you mentioned. Because for me, the children are the silent victims in a divorce. They don't have a voice. And it's not something that we've discussed yet, Bill, but the main reason for me actually starting this series of Let's Talk Divorce on Impact Makers Radio is, it's a personal thing. I myself was a child of divorce, and my parents had a very volatile, a very violent divorce. There was lots of fighting, lots of shouting, lots of blood. I was barely 10 to 11 years old at the time, and myself and my younger brother, we were caught in the middle, the ping pong game. Your mother talking bad about my father, and vice versa, and we ended up blaming ourselves for the divorce. And it took me at least 20 years to deal with the emotional fallout of being caught up in the divorce as a young child. It had a massive negative impact on my life, on my confidence, on the decisions I made as a young man, on the relationships that I went into. Fortunately, both my brother and I didn't fall by the wayside and end up in crime or drugs or anything else that's negative, that quite a lot of children of divorce do end up going into. So this is the main reason for me actually starting this series, to bring professionals like yourself on, and for you to have a voice to speak to the listeners out there, to speak to those people who find themselves in that unfortunate position of being in divorce, and their they've reached that point where they can no longer amicably communicate with themselves, and the children are getting caught up in the middle. So my hope is that through this show and through the professionals like yourself, that the listeners will take a different perspective, see things in a different way, and love their child more than they hate themselves. So I've just shared my personal story, and even today, I'm 55 years old today, and still it rears its ugly head now and again, you know, the things from the past. So it's just really important for parents, as you're listening out there right now to our guest today, for you to realize that no matter what situation you find yourself in, the children must come first. And I'm just curious, because you touched on this very slightly in your answer then, Bill. What would you say to the listeners, to divorcing couples right now who, for whatever reason, and they may rightly feel so, they may rightly be angry, they may rightly have anxiety, they may rightly feel they've been untreated, but what insights would you share with them if the children are caught up in the middle?
Well, I think there are a few things. One is I always explain to clients that, as you mentioned, your issues involved in your parents' divorce and how it impacted you. Clients don't realize they tend to view the children are doing well, they're fine. I always try and explain that children are not always going to say things that are bothering them. A lot of times they keep things bottled up, right. And they really have to help provide an outlet for their children. If they're not speaking to their parents about how they're feeling during the divorce, I encourage them, have them talk to, whether it's a counselor at school, whether it's a counselor or a therapist that they go to privately, whether it is a priest or a rabbi or someone through the church, or even a family friend, anyone the children can speak to and provide an outlet for them to explain how they are feeling through the process. And what you mentioned in terms of you and your brother both feeling as though this was your fault, your doing, is very common. And parents not only need to explain that to the children, that this doesn't have anything to do with them, the process, but also give them an outlet and make sure that they have that available so that they can express how they're feeling, and if they do express certain concerns and issues, that the parents can address that. And that leads me to another point that I always make to clients, which is parents need to talk about these things together, talk about the children, and address issues with the children together. Just because they're getting divorced and they may not get along very well, the children, as you said, are victims in this process. And the parents really have to be mindful of how this is impacting the children and really try and be civil to each other when it comes to the children. From all the research we have, from all the studies, it's clear that the children who, obviously you and your brother turned out okay, but the children who turn out the best, who need the least amount of help, they'll have the fewest issues as adults when their parents got divorced, are children whose parents got along well enough that they can stand next to each other on the soccer field during the game, and they can stand next to each other during graduation and congratulate their child, and they can have a conversation with each other and be on the same page when it comes to issues that come up regarding the children. Because that's another thing that will happen is children will play one parent against the other. Exactly. Very common in divorce cases, and parents have to be aware of that. And what prevents that from happening is parents speaking to each other on a regular basis and saying, hey, little Johnny said this to me. Has he said anything similar to you? What's going on when he's at your house? And that ensures the parties know what's going on and they're on the same page in terms of how should we deal with this if an issue comes up. How are we going to address this? A judge that I appear in front of regularly here in Hunterdon County, said one time when I was in court to parties who were not getting along well, the child has enough love for both of you. You don't need to compete with each other. You don't need to try and make yourself out to be a better parent than the other party. It's not about that. It's about making sure your child is well adjusted, has what they need, has support from both parents, because it is a difficult process. Obviously, it's difficult for the parties. It's especially difficult for children.
Thanks for sharing that with us, Bill. Those are some great insights, and based on truth, based on reality, and I can only underpin everything what you said, and especially for those parents who think, as you mentioned, the children are going to be fine. Well, take it from me, as a child of divorce, you're not fine, and we pick up on every little nuance, even though you may think that your child or your children don't know what's going on. They see and feel everything, and the worst thing is they internalize that and carry that with them. So as much as you may be at each other's throats, and as much as you may hate each other's for whatever reasons, love your children more than that. That's all I have to say on that point. So let's circle back then now, Bill. Just as a quick reminder, today's topic is using alternative dispute resolution methods to settle your divorce case. Now, with that in mind, Bill, and for those people in divorce who are listening in right now and they are wanting to know more, what's the most common but unknown pitfall that they need to be aware of, no matter what situation they find themselves in?
Well, I would say, in terms of alternative dispute resolution, when parties are going through mediation, I think the biggest pitfall is not consulting with attorneys before they start the process and while they're going through the process. I've seen cases where parties have gone through the mediation process without ever having consulted with an attorney, and they're not aware of the law. The mediator cannot give them legal advice, and after they complete the mediation, they take their proposed agreement to an attorney after the fact, and then they find out the agreement is completely one-sided, and it's unfair to them. Unfortunately, in those cases, oftentimes the mediation process has been a waste of time, because once the attorneys get involved, the proposed settlement blows apart. It's always better to have met with an attorney for a consultation before starting the mediation process. That allows the client to understand the law, how it applies to the facts of their case, and understand their options before negotiating during the mediation process. It's also a good idea for the parties to have an attorney that they can consult with during the mediation process in between sessions, because the mediator can't give them legal advice. The mediator can't give them a wink and say, hey, this is a really good deal for you, you should agree to it. That's something only their attorney can do. In collaborative divorce, which is also an alternative dispute resolution process, one of the pitfalls I see is clients not being patient with the process. The collaborative process is essentially a series of meetings or conferences with the parties and their collaboratively trained attorneys. Occasionally, these cases will settle after only one or two of these meetings, but typically it will take longer than that. And the clients need to be patient and not get frustrated if the case is not immediately settled. It's a great process, and ultimately will provide a settlement that's going to be much less expensive than litigating the case, but it's not always instantaneous, no matter how fast people want things to move forward. These cases also tend to be delayed to a certain extent if one party doesn't really want to get divorced. They can sort of grind things to a halt, not always intentionally, just because in the back of their mind they have this idea that they don't really want to get divorced, and this notion of the longer it goes on, maybe my spouse will change their mind and we won't get divorced. So I think there are certainly some pitfalls to mediation and collaborative divorce, but not nearly the same pitfalls that you have in litigating cases, and certainly the focus, circling back to what you brought up in terms of the children, the focus in mediating and collaborative divorce is really what will be best for the children, and how are we going to structure a settlement that is going to help them go through not only the process but post-divorce and their lives in the future.
Let me ask you this. How long have you been practicing family law?
I've been practicing family law for more than 15 years at this point in time.
Right, so would it be fair to say that within that 15-year span of time that you have possibly helped hundreds of people in their divorce cases?
Oh, absolutely.
Okay, so imagine this then, Bill. It's any day of the week. It's a Monday, Tuesday, Wednesday, whatever the case may be, and it's 6, 7 a.m. in the morning. Your alarm clock goes off if you still use one of those things. But anyway, you're up bright and early and bushy-tailed and ready for another full day's work ahead of you, helping your clients, these people who find themselves in the unfortunate position of facing a divorce. Now, after 15 years and working with so many clients, how does Bill Rudnik feel on a morning like that?
Well, I think initially I'm happy when I wake up because I have my wife, I have my kids, and from dealing with divorce cases, I understand a lot of what ultimately ends up in people getting divorced. But in terms of my work, I think I start with that mentality, and I view it in terms of how can I help people today. And as I am driving to the office, I think about what I have on my calendar that day, who I'm going to see, what cases I'm going to work on, whether I'm going to be in court or I'm going to be in my office. And I really think about what are ways that I can help bring these cases to a resolution as quickly as possible, as easily as possible, as inexpensively as possible. And those are the types of things that I try and focus on as I'm thinking about the case. I try and think in terms of creatively, what can I do that may be something outside the box that can help bring about a resolution to whatever the problem is in the case. I tend to try and get my clients to think about what the other side is looking for in the case, what is driving the other side, and get them to understand the other side's position, not simply to be sympathetic for what the other side is going through or what they're feeling, but also to try and get them to understand that the way to settle the case and get you what you want is for you to understand what the other side wants and figure out a way that we can get them what they want as well. And I think that is helpful in trying to negotiate these cases. And of course, the children, if there are children involved, I try to keep them focused on what will be best for your children. I get a lot of questions during these cases. Well, I'm thinking about doing this, or, this happened, how should I address it? And a lot of times there are little things that happen that may be annoying, but in the grand scheme of things, you try and get the client to understand, look, this is not something that you want to make an issue of. It's not something that, ultimately is going to help to settle the case if you start fighting about every little thing.
Okay, so now that we know a little bit about you and how you feel on a typical day as you're out there working with your clients, just expand a little bit on that for us then, Bill, if you would, and briefly tell us a little bit about yourself in terms of your background and your formal education and your experience as it relates to the topic of family law.
Sure. So I grew up in New Jersey, actually in Hunterdon County, which is where my office is located. I received my undergraduate degree from the University of Notre Dame, my law degree from Villanova University School of Law. Initially, I practiced civil litigation for a firm for a few years, and then I came to Gebhardt Kiefer, my current office. I've been here for over 20 years. I did do some civil litigation work for a few years here before I transitioned into family law, and as I said, I've focused on family law now for more than 15 years. I am a certified matrimonial law attorney, which basically means I have a certain level of experience. I've settled a certain number of cases. I've tried a certain number of cases. I had recommendations from judges, and I had to take a test in order to get that certification. I'm also trained in the collaborative divorce process and also trained as a mediator, which are the two alternative dispute resolution methods that I mentioned earlier. I am a member of the New Jersey State Bar Association Family Law Executive Committee, as well as the co-chair of our Hunterdon County Bar Association Family Law Practice Committee. I often speak at seminars involving alternative dispute resolution, custody, attorney ethics, and domestic violence. From a personal standpoint, I am divorced, remarried. I have a son from my first marriage. I have a stepdaughter as well as a daughter with my wife. So I have a certain perspective, having gone through the process, having been divorced, also being remarried, and having a child from my first marriage. I have a certain perspective that I feel as though I can relate to my clients and a lot of the issues that they go through as they're going through the process.
So just in case there are any young budding lawyers out there thinking about becoming a family law attorney, you do not have to get married and divorced first, okay? Just thought I'd mention that one.
That is true.
That is true.
I don't recommend the divorce part. I do recommend the marriage.
Oh, Bill, we got to have some fun. Now, listen, we're coming towards the end of the show. So I'd just like you just for a moment to picture the kinds of people who come to you for your help and they're wanting to dig a little bit deeper into the topic of using alternative dispute resolution methods to settle their divorce case. With that in mind then, Bill, what final thoughts would you like to impart with them before we move on to our last question for the day?
I would say it's important to keep an open mind as you go through the process. Listen to your attorney's advice. That is what you're paying your attorney for. You want to obviously make sure you have a good rapport with your attorney and that it's a good match in terms of personality-wise. But the smartest clients that I've had are the ones who realize they are not an expert in this process. They're not an expert in divorce law, and they rely on my advice as they're going through it. I've had some clients who I consider to be brilliant people in their fields, and although they're an expert in their field, they realize that they're not an expert in divorce law, and they rely on my advice. And those are the cases that, at least from my standpoint, tend to go much smoother because the client is not necessarily trying to control the process. They're listening to my advice. They're relying on what I'm telling them, how they should act as they're going through the process. And they're also, what I mentioned earlier, trying to view the case in terms of what's best for the children, what the other side's position is, and let's see if we can come up with some solution that meets the needs of the children, meets the needs of the other party, and meets our own needs. And I feel as though that puts them in the right mind frame to try and settle the case. You need to put them in a position, what I mentioned earlier, in terms of a reasonable position, also just globally viewing how are we going to bring this case to a resolution.
Right, so Bill, if someone feels they want to know more about using alternative dispute resolution methods to settle their divorce case, what's the easiest way for them to reach out to you?
So my office number is 908-735-5161. I can be reached by email at brudnik@gklegal.com. And that's also my firm's website. Gebhardt Kiefer's website is gklegal.com. I also have profiles on LinkedIn and Avo, so you can reach me through those sites as well.
Okay, folks, so whether you're out there and maybe you're just taking a walk and you're listening in on your personal headset, or you might be even out for a drive and you're cruising down the highway, whatever the case may be, that's all we have time for today. Again, that was family law attorney William J. Rudnik, commonly known simply as Bill to all his friends and colleagues. Thank you so much for sharing so generously with us today, Bill. You have certainly demonstrated that you are a true educator and advocate for your client's success. So thank you.
Thank you, Stewart.
You're so welcome, Bill. And I'd also like to send out a big thank you to you. Thank you to you, the listener. Thanks for joining us on this very insightful and informative discussion with one of the leading family law attorneys in the Clinton, New Jersey area today. Again, as a reminder, his name is Bill J. Rudnik. Remember his name. Make sure you do check him out. Give him a call. He just shared his phone number. Visit his website. Whatever you do, I am sure you are going to be in the right place to get started. So that's it, folks. Again, my name is Stewart Andrew Alexander, and we'll be back shortly with some more leading family law professionals in this, our series of Let's Talk Divorce Conversations. So until then, take care, have a great day, and we'll talk real soon.
Thank you for tuning in to Impact Makers Radio. To listen to all past, present and future industry thought leaders and trendsetters, visit us at impactmakersradio.com.